All right, good morning, folks. Thanks for the grace on letting us get our presentation up and running. My name is Megan Glowacki. I'm a partner in the Thompson Hine Labor and Employment Practice. I'd like to take a moment to welcome you to today's webinar. And first, let me just say I've had the opportunity to work with many of you over the years. So first, a bit of a personal note. I hope you're staying healthy. I hope you're staying sane. We are here at Thompson Hine grateful to be working with you in these unprecedented times. We'll get right to the point of today's webinar, which is the new Families First Coronavirus Response Act. This presentation is going to be specific to small employers, tailored to help you understand the exemptions, potential exemptions, I should say, for those of you who have less than 50 employees and some other exemptions that may be applicable to you if you have less than 25 employees. During the webinar, of course, please feel free to use the question box typically located in the control panel to the right side of your screen to submit questions. If you were able to submit questions beforehand, I have incorporated those questions into this presentation. I'll also try to answer any questions that we have at the end. If I can't get to your questions during our time today together, of course, I'll respond via email after the webinar, and a recording of this webinar will be available later in the week. So with that said, let's jump right into things. Last week, President Trump signed the Families First Coronavirus Response Act, FFCRA. The leave provisions of the Act go into effect on April 2nd. So what we're trying to do between now and April 2nd is understand what the requirements of the bill are and to ferret through, quite frankly, congressional legislation that, as many of you know, isn't necessarily made by or written by business people. We expect, and let me just say, before any of this is set in stone, that the DOL is supposed to issue guidance this week, hopefully this week, that will clarify some of the many ambiguities and questions that we have about what Congress intended by this Response Act. There are two main provisions of the Act, and they apply only to those employers with fewer than 500 employees total. So if you have more than 500 employees, feel free to exit the webinar. If you have fewer than 500 employees, you need to pay attention to each of these specific obligations. So two main provisions. I'm going to tackle each of them separately. The first requirement is to provide 80 hours of emergency paid sick leave. The second major requirement is to provide 12 weeks of emergency FMLA. I'll call it EFMLA for purposes of my own tied tongue. And there are some exceptions for employers with less than 50 employees, as I previewed at the beginning of the webinar. This chart was designed by me and very fancy, as you can see in the coloring. And it's frankly essential to help you understand what the provisions and requirements are based on the number of employees. So I'll tee this up now. We'll circle back around to this at the end of the webinar for refreshing. But if you have fewer than 500 employees but more than 50 employees, all of the provisions are going to be applicable to you, including the two main buckets that I just addressed in terms of paid sick leave and the 12 weeks of EFMLA. If you have fewer than 50 employees, you may be exempt from one specific provision of the Paid Sick Leave Act. All other provisions of the Paid Sick Leave Act are going to be applicable. You may be exempt from EFMLA. If you have fewer than 25 employees, Again, you may be exempt from one provision of the Paid Sick Leave Act. All other provisions are going to apply. Again, you may be exempt from EFMLA, but if emergency FMLA is applicable, employers with 25 employees may not be required to restore employees who take EFMLA to their regular position. So this is a high-level overview. We'll circle back around to this at the end when hopefully all of these provisions have synced up and make more sense. So starting with emergency paid sick leave. Again, if you have fewer than 500 workers, effective April 2nd, there will be an obligation to provide employees who cannot work or telework with 80 hours of paid sick time off. Better said, if an employee is capable of teleworking, they are not eligible for the paid sick time off. Employers must front the money for the paid sick time and then will be reimbursed by the federal government as part of your quarterly tax payments. And fear not, we will certainly cover the tax credits at the end of this webinar. What are the eligibility requirements for paid sick leave? There are technically there's 6 buckets. Nobody really knows what the 6th bucket meant, so we'll start with the 5 important buckets, and I've broken them down specifically because it matters which bucket employees fall into for purposes of what amount of pay needs to be provided and what level of tax credit you can receive. So I promise there is method to the madness here. So if the employee is subject to a COVID-19 quarantine or isolation order, if an employee who has been advised by a healthcare provider to self-quarantine due to COVID-19 concerns is out of the office, or if an employee seeks leave because they are experiencing symptoms of COVID-19 and are seeking a medical diagnosis, employees will be eligible for paid sick leave. One natural question that has come up is, if I am living in Ohio, Indiana, Michigan, and I'm now subject to a stay-at-home order, and perhaps I'm a non-essential business, therefore my business is not operating at the moment, or I'm only operating if I can telework, does the first bucket of this paid sick leave apply? Does that count basically as an isolation order? And I'm going to punt a little bit on this one and say we don't know yet. I'm hopeful that the DOL is going to provide guidance on what exactly they meant by an isolation order. If they don't provide guidance, right now, my recommendation and my reading of some of the text and the background of how this bill made its way through Congress is that the isolation order is not intended to cover folks who are subject to a stay-at-home order. That the isolation order was to accommodate or to account for employees who have to self-isolate because the employee has been diagnosed with coronavirus. So more to come on that point. This is obviously a key issue given that a number of states have now issued stay-at-home orders, and if the stay-at-home order is considered an isolation order, paid sick leave would be available starting April 2nd. But I would say for now, I think you can feel comfortable taking the position unless there's further guidance that an isolation order is not the equivalent of a stay-at-home order. There's another 2 sets of buckets on this paid sick leave, and bucket 4 and 5, as I've been referring to them, are the caring for others bucket. So first, if an employee cannot come to work because they are caring for another individual that is subject to a COVID-19 quarantine or isolation order, or if they're caring for an employee who has been advised by a healthcare provider to self-quarantine due to COVID-19 concerns. If they're caring for a child whose school or place of care, daycare has closed or the child care provider is unavailable, those provisions would enable the employee to receive paid sick leave. How much paid sick leave? For full-time employees, up to 80 hours. For part-time employees, we're going to prorate the portion equivalent to what their average hours worked in a 2-week period are. And again, as I mentioned before, sick leave is available for immediate use starting April 2nd. There is no 30-day grace period. Employees can begin using it on April 2nd if they meet the eligibility criteria for using the sick leave benefit. This is another important chart, and I should mention that I believe we'll send the slides out after the webinar, so don't feel like you need to screenshot or write down furiously. The point of this slide is the use of paid sick leave, meaning which bucket an employee uses, is going to dictate what the level of their pay is for that sick leave use. So if employees use paid sick leave for a reason that falls into buckets 1, 2, or 3, their paid sick leave is paid at their normal rate of pay up to $511 a day. However, if the employee is using paid sick leave for a reason that falls into bucket 4 or 5, the caring for others bucket, then their paid sick leave is paid at 2/3 of their normal rate, up to $200 a day. And the reason this is important is that the tax credits are going to mirror what you should be paying for the paid sick leave. So for example, if an employee took paid sick leave to care for a child whose school was closed, and you as the employer paid that employee not 2/3 of their regular rate of pay up to $200, if instead you paid them at $511 a day, when you seek reimbursement from the government, you will only be able to be reimbursed for the $200 a day. So potentially you've paid the employee an overage of $311, or at least an overage on what you can recoup from the tax credit reimbursement. So as you can imagine, some of the challenges with this will be ensuring that when employees are absent, we know exactly the reason for their absence so we can appropriately code which level of paid sick leave they will be entitled to. As I referenced before, wages, the paid sick leave that will be provided under this is tax reimbursable. There are other provisions that state that the wages required to be paid under the emergency sick leave provisions are not going to be subject to the 6.2% Social Security payroll tax that are typically paid on employees' wages. To be clear, the provisions of this act requiring paid sick leave expire on December 31st of this year. The paid time will not carry over from year to year. Employees do not accrue paid sick time, so that if, for example, an employee does not utilize 80 hours or utilizes no hours, they would not be entitled to a payout upon termination of the paid sick leave. And just as further clarity, employees only receive one lump sum of 80 hours. It is not that an employee can use 80 hours of paid sick leave in the month of April and then again get another 80 hours of paid sick leave in the month of June or August. It is simply 80 hours of paid sick leave between April 2nd and December 31st, 2020. Some other emergency sick leave obligations. Important here to understand that just because you already offer paid leave does not exempt you from the Act. In other words, if you provide employees 2 weeks of vacation, you cannot say that those 2 weeks of vacation cover you for purposes of paid sick time. If you offer benefits that are more robust than the paid sick leave benefits, you obviously can continue to give employees those better benefits. A significant important issue with respect to paid sick leave and the emergency FMLA will be how we communicate these new benefits to employees. And frankly, the communications are important for two different reasons. On the one hand, we want to make sure we balance notifying employees of their right to take paid sick leave and emergency FMLA, balanced against the need for an employer to continue operating their business. As you can imagine, if everybody took 2 weeks of paid sick leave at the exact same time to care for children whose schools have been closed, it's going to be difficult for an employer to continue to manage that business with that level of absenteeism. On the other hand, communication is important, particularly if you offer more robust benefits. We don't want employees to feel like we're taking something away from them because of the Paid Sick Leave Act. So if you have an unlimited PTO policy, or if you provide various very generous benefits to your employees in terms of paid leave, consider whether you should have a communication that makes sure that employees understand they're getting these benefits, but that you may be supplementing their pay up to their full rate of pay. For example, if somebody's using paid sick leave to care for a child whose school has closed and they'd initially only be eligible for 2/3 of their pay, up to $200 a day, your own policies may supplement that daily pay so that the employee is made whole. Of course, you're going to want to look at this in a broad perspective to make sure that we can continue to provide those benefits, but that's why communication with employees is extraordinarily important when it comes to these benefits. Technically speaking, we cannot require an employee to use other available paid leave before using sick time. And the reason being is typically your company-provided leave, your PTO, vacation, other paid sick leave benefits that are company-provided do not provide the job protection that the Act's sick leave will provide. So for that reason, the government has said that employees must be able at their own discretion to use available paid sick time before using any other type of leave. And I'll just note that there are some very narrow exemptions if you have employees who are healthcare providers or emergency responders. You may be able to elect to exclude those employees from the emergency sick leave provision. So how do we manage this practically? As I mentioned before, we will need documentation to show which bucket of paid sick leave was being utilized by the employee for both payment and reimbursement purposes. It probably makes sense for most employers to have a checklist, some other type of written form that separates out the buckets that we've been talking about in this webinar, that somebody, whether a supervisor, HR, whoever accepts call-offs, is going to be recording the date and the specific utilization of paid sick leave, and then we're keeping that documentation in case we ever need to prove for purposes of the government what paid sick leave was paid at what level. The type of documentation that will be required by employees themselves to prove the need for leave remains unclear. Better said, or as I might give an example here, if you have an employee who says that they are feeling like they have symptoms of COVID-19 and need to seek a medical diagnosis, the question naturally becomes, well, can I request from that employee a doctor's note that they're not feeling well? Can I request a note that they've at least seen a medical provider in order to get some assurances that the employee just decided not to come into work today and wants to use their paid sick leave? At this point, we don't have guidance from the Department of Labor to establish what that documentation should be. If we don't receive further guidance from the DOL, I recommend that you default to your customary and reasonable documentation practices for when employees are otherwise calling in sick and unable to come into work. Just a few other notes here in terms of your employer obligations. You will be provided by the Labor Department a model notice containing information on the paid sick leave provisions, and that notice will need to be provided to employees in the ways that you would normally provide such Department of Labor guidance. So to be clear, the leave provisions become effective April 2nd. They expire on December 31st. If you allow employees to take paid sick time before April 2nd, I warn that that time will likely not count for purposes of the Act unless we get DOL guidance that says that we can apply these provisions retroactively. And this is important because if you are giving paid sick time before April 2nd, you will not be able to be reimbursed by the government for that paid sick time. And then effective April 2nd, you will have an obligation to provide the 80 hours of paid sick leave. If you are scratching your head as to how you would be able to afford even 80 hours of paid sick leave to employees, there are some potential exemptions for those businesses that have fewer than 50 employees, but I warn that those exemptions are narrow. So if you have 50 or fewer employees, the bucket number 5, the caring for a child whose school or place of business is closed, is the only bucket where you may be exempt from having to provide paid sick leave for. And the Act says that employers are exempt when the imposition of such requirements would jeopardize the viability of the business as a going concern. That's difficult to put into clear and objective criteria what that means. Over this past weekend, we had a note from the DOL that indicated that they were going to put out simple and clear guidance as to when an employer would be able to utilize this exemption. But I warn that all other paid sick leave requirements, all of the other 4 buckets we discussed, are applicable. And keep in mind that there may be situations where more than one bucket applies at a time. And so even though somebody may be out on leave to care for a child whose school is closed, if they also indicate that they are not feeling well and are experiencing symptoms of COVID-19, if you're an employer with less than 50 employees, you may be exempt from bucket number 5, but not exempt from bucket number 3. So moving on to the emergency family leave provisions of the Act. Please pay attention. Even if you have fewer than 50 employees and traditionally are not subject to the FMLA, the Act continues to apply to you even though the other traditional FMLA aspects do not. So all employers with fewer than 500 workers have to provide up to 12 weeks of EFMLA for eligible employees who are unable to work or telework because they have to care for a minor child if that child's school or place of business or school or place of care has been closed. I mean, honestly, at this point, I might put my child to work, given how little homeschooling he's actually taken to doing, but that was a Freudian slip there. So for EFMLA, forget the traditional requirements that an employee has to have worked 1,250 hours in the last 12 months. For EFMLA only, all employees who have been on the job for at least 30 days are eligible for emergency family and medical leave. And I guess let me just say, if you are an employer with more than 50 employees and you do typically offer FMLA for the traditional FMLA uses of a serious health condition or to care for a family member with a serious health condition, all of those provisions remain the same. So for purposes of today's webinar and for purposes of EFMLA, really put that in its own separate bucket with its own separate requirements for eligibility. In terms of pay, this is a bit of a head-scratching notion. FMLA traditionally is unpaid. Emergency FMLA is paid for a fair portion of it. So the first 10 days of leave can be unpaid, although an employee can likely opt to use their accrued PTO or the paid sick leave from bucket 5 that we talked about before during that 10-day period. The remaining 10 weeks of leave are paid at 2/3 of the employee's normal rate of up to $200 a day. Again, just like the paid sick leave, wages paid for EFMLA will not be subject to the 6.2% Social Security payroll tax typically paid on employees' wages. So breaking this down, if you are an employer with more than 50 employees, EFMLA is not an additional 12 weeks on top of the 12 weeks you're already giving employees for FMLA. For example, if you have had an employee who has used 6 weeks of FMLA for their own serious health condition, effective April 2nd, they would be eligible for 6 weeks of EFMLA. They do not get a new 12 weeks of EFMLA on top of the 6 weeks already utilized. Employers with fewer than 50 employees, you may be exempt from the EFMLA requirements, again, when the imposition of those requirements would jeopardize the viability of the business as a going concern. So everyone should be clearly attuned to an alert we will certainly have as soon as the DOL guidance is issued on what that simple and clear criteria is to be exempt from this provision. Assume for the sake of argument for the moment that the EFMLA provisions apply. Generally speaking, the employee on leave must be restored to his or her prior position when they come back from EFMLA. If you are an employer with fewer than 25 employees, you may be exempt from the requirement to restore the employee to their prior position if the position held by the employee on leave no longer exists due to economic conditions or other changed operating conditions because of the COVID-19 pandemic, and if the employer has made reasonable efforts to restore the employee to an equivalent position, even if it is not the same position that they held. Keep in mind that there is another portion of the EFMLA that would require employers with 25 employees for a year after the EFMLA was utilized to consider that employee for equivalent positions that might arise. So unfortunately, it's not as though when you cannot restore an employee for these specific reasons, you are free and clear of that employee, you then still have an obligation for a 1-year period to consider them for new openings that might arise. Can leave to care for a child whose daycare or school has closed be used intermittently? The answer right now is no. The regular provisions of FMLA set forth the right to intermittent leave, and this section was not amended by the new act. It's possible that DOL guidance can change our view on this, but for now, the recommendation is that leave is not to be taken intermittently. So circling back to my chart here, if you have fewer than 500 employees, you are subject to both the 80 hours of paid sick leave and the 12 weeks of EFMLA, 10 weeks of which was paid, the first 10 days of which is not. If you have fewer than 50 employees, be on the lookout for potential exemptions to the paid sick leave bucket to be used for someone who is absent because their child's school or daycare has closed. All of the other buckets with respect to paid sick leave are applicable. And if you have fewer than 50 employees, you may be exempt from EFMLA if it could cause the business to go under. If you have fewer than 25 employees, again, may be exempt from bucket 5 of the paid sick leave. All other provisions of paid sick leave are applicable. You too may be exempt from EFMLA. And if EFMLA is applicable, you may not have to restore employees to their current position. So talking about employer tax credits, and then I'll turn to questions. As I mentioned at the beginning, employers receive 100% reimbursement for the paid leave provided pursuant to the Act. Employers face no payroll tax liability on this. Again, the sick leave credits depend on which type of paid sick leave bucket you are applying to. But in essence, the paid leave that you are going to provide to the employee is equivalent to the paid credit that you can receive from the government. The same is applicable to the emergency FMLA. Look, we are all sort of anxiously looking for guidance from the DOL this week on the tax credit issue. What we have heard so far is that eligible employers who pay the qualifying sick or child care leave will be eligible to retain an amount of the payroll taxes equal to the amount of the qualifying leave that they paid, rather than deposit it with the IRS. And that payroll taxes that are available for retention include federal income taxes, the employee share of Social Security and Medicare taxes, as well as the employer share of those taxes for all employees. And that if there are not sufficient payroll taxes to cover what you paid out to employees as sick leave or EFMLA, employers will be able to file a request for an accelerated payment from the IRS. And the IRS expects to process those requests in 2 weeks or less. And the DOL has provided us some examples of how they anticipate this working. So in the first example, if an eligible employer paid $5,000 in sick leave and is otherwise required to deposit $8,000 in payroll taxes, including taxes withheld from all of its employees, the employer could use up to $5,000 of the $8,000 of taxes it was going to deposit to make the qualified leave payments. And so the employer would only be required under the law to deposit the remaining $3,000 on its next regular deposit date. If an eligible employer paid $10,000 in sick leave and was required to deposit $8,000 in taxes, the employer could use the entire $8,000 of taxes in order to make the qualified leave payments and then the employer can file a request for an accelerated credit for the remaining $2,000. One really important question that has come up from a number of employers of all sizes within the 500 employee is, what do I do if I have decided or am trying to decide between furloughing an employee or temporarily laying them off, although not issuing a termination, or simply putting them on an unpaid leave during this economic crisis? What will the act apply to them? And the answer, as we understand it right now, is yes. If an employee remains employed, even though they are on an unpaid leave, if they have a qualifying need for paid sick leave because they are on your payroll books as an employee, they would be eligible for paid sick leave or emergency FMLA. The act does not apply if employees are terminated. So let me turn to questions, because I see a number of them have been rolling in. And as I said before, if I'm not able to answer all of your questions, we will certainly respond to them after the webinar. Give me a minute. Okay. First question, what should the FMLA process look like as we have never had to file before? It's a fabulous question. So if you have less than 50 employees and are not typically subject to FMLA and therefore have no defined FMLA policy, as you wouldn't, the eFMLA process, now that emergency FMLA applies to you, should probably look quite a bit like a documentation of anybody else who is going to be on an extended leave of absence. I am hopeful that we'll get from the DOL some guidance on the type of certification we can utilize for somebody to attest to the fact that they do, in fact, have a child at home whose school has been closed, and that they themselves are required to care for that child. In a typical FMLA situation where somebody is using leave to care for themselves because they have a serious health condition or to care for somebody else, the DOL has provided certification forms. However, those certification forms go to a third party, a doctor, to identify the need for leave. Here we're in a bit of an odd predicament where we probably can obtain from public records that the child's school has closed, but the certification would come from the employee themselves that there is no one else to care for their child. So we're looking to the DOL to provide some guidance on what sort of forms we can require of employees to confirm that they have the need for FMLA leave. When you do have confirmation that eFMLA is necessary, you would want to record exactly when that eFMLA was utilized so that if audited by the government, you have the documentation to show when eFMLA was utilized and then subject to your reimbursement. Second question, if we have an open PTO policy, can we even mandate the emergency sick leave? I'm not sure I completely understand what an open PTO policy is. Perhaps it means an unlimited PTO policy, or one where employees can take PTO as needed, not necessarily subject to any cap. Yes, the way the law is written, employees are entitled to the emergency sick leave because, as I stated before, it is a government-provided benefit in the fact that it is a job-protected leave. So if you are going to continue to allow folks to take unlimited or open PTO, you would want to decide whether you're going to cover or supplement anything between the $511 and $200 cap on the paid sick leave and the employee's total pay to make them whole. And then you'd want to communicate to employees that they have in fact utilized the statutory leave so that they understand that they have been provided with that benefit and that that benefit is now complete. Third question. You mentioned that if an employee is eligible to telework, then he/she is not eligible for emergency paid sick leave. Is that true under all conditions you cited, i.e., the employee has symptoms, is caring for an individual? Yes, that is correct. If an employee has the ability to telework, then the paid sick leave provisions in the EFMLA are not applicable to them. Now, certainly, whether someone can actually telework while they're feeling unwell or while they're caring for a child whose school has closed is probably going to be a subjective, perhaps even case-by-case determination. And you may have somebody who says, look, I've tried teleworking for 2 weeks now, and quite frankly, my children are driving me insane. I can't do this anymore. I'm not able to telework. So I would recommend sort of working through with those employees on a case-by-case basis, although encouraging teleworking as much as possible. Next question. We do offer unlimited PTO. Does the Families First Act create any exposure that should prompt me to reconsider or somehow caveat the unlimited PTO policy? That's a great question. I think it's fine to continue an unlimited PTO policy, particularly if that is something that keeps employees sane, keeps employees coming to the office, and keeps employees motivated for the times when they can. I would say that it's very important to make sure employees understand that they have been given the paid sick leave benefit and when they have been given the paid sick leave benefit, because the unlimited PTO policy can always be changed by an employer going forward. For example, if we get into a worst case scenario where come June we are still operating under the same circumstances as we have today, you may decide you don't want to be as generous with the unlimited PTO policy, and it is certainly your right as an employer to change that policy on a go-forward basis. What we don't want is for employees to claim then that they haven't been provided the sick leave or the EFMLA that they're entitled to under the Act. So my recommendation is to make sure in our communications with employees that they know and become aware of when they have utilized the leave, so that you can have the freedom to change employer-provided benefits as needed in the future. And there have been a couple of questions on here, about would we be able to provide some wording regarding notification of this to our employees? And I would say absolutely. There's two different types of notifications. One is obviously the DOL notice that will have to be posted, but the communication to employees is obviously more nuanced, tailored to your business, and straddles, as I said before, sort of our competing interests in making sure that employees know about the leave, but are also incentivized to continue working during this time to the extent that they naturally and possibly can. Okay, a couple more questions, folks. I appreciate you sticking with us here. Next question is, what protection, if any, do employees have if they refuse to come to work out of fear of getting sick? I've seen this a lot, and the question goes on to say, they are not showing symptoms and they do not have to care for anyone. They are just choosing to follow the governor's orders to stay home and not to go to work. Under the paid sick leave and the EFMLA, there is no provision for somebody who prophylactically would like to avoid coming to work simply out of fear of becoming ill. So from a statutory perspective, under the Families First Act, there is no requirement to provide them paid sick leave or EFMLA. I will caveat and say that under the ADA, if you have an employee who has a pre-existing medical condition, is immunocompromised because of those pre-existing medical conditions, and they do themselves have a very real risk of contracting COVID-19 if they're exposed to too many people, under those specific set of individualized circumstances, you may have an accommodation requirement under the ADA to provide an unpaid leave of absence. Absent that circumstance, though, you are entitled to make that employee utilize their own paid time off to assess attendance points where needed. And during the stay-at-home order, that even applies if you are an essential business that is continuing operations here in Ohio. Of course, through the governor's current stay-at-home order, we probably want to be analyzing, to what extent employees can continue working remotely from their homes. But if you have decided that you are an essential business provider and that employee's services cannot be performed from home, you do not have to offer paid sick leave under the Act or emergency FMLA. If we have, next question, if we have an employee who cannot fulfill their full 8-hour workday or full 40-hour work week due to daycare closure, would they be able to use this to cover the missing work hours due to the fact that they leave work early to care for their child? And I think this question is the one I've been asking, which is, let's make sure that we can't use EFMLA intermittently, which is, I need to leave work after 6 hours because I need to relieve my spouse who's been watching the child whose school is closed, and we need to switch on and off. As I currently read the Act, absent DOL guidance, there's no requirement to allow an employee to use EFMLA intermittently, though the employer and the employee can choose voluntarily to do so. Now, the risk with that is once you allow one employee to use intermittent EFMLA, you very well may have set a precedent for how other employees are going to want to utilize it, but there's no requirement to allow the employee to use EFMLA intermittently. Okay, next question. Can we alter our PTO requirements? Should we alter our PTO requirements as a result? You can always alter your PTO requirements on a go-forward basis, but I do warn that employees may view that as sort of a retaliatory action for the use of the paid sick leave. Again, I think it's all about how we communicate these usages to our employees. And I'll remind you as well that the employees have to be able to utilize their paid sick leave under the Act before their current PTO. Next question is, do union members count towards the 50 employees for the small business exemption? It's a question I've been getting a lot, which is a good one. And the answer is union employees are not treated any differently than normal or regular employees. for purposes of the Act. So strip off the union label and just count all employees when determining whether you have 500 employees or 50 or fewer employees. Okay, a couple more questions here, folks. If an employee just doesn't want to come to work because they are scared, do we have to provide unemployment? There's a couple questions in this, so let me start with that. If an employee just doesn't want to come to work because they are scared, we have to provide unemployment. Obviously, unemployment is dictated by your state's regulations, and many states have broadened eligibility requirements for folks who are out of work or have reduced hours because of unemployment. I believe in most states at this time, though, an employee's own prophylactic choice not to come to work because they are afraid is not going to qualify them for unemployment. The second part of this question, though, is that if they have a child with autoimmune issues, then do we have to provide unemployment or other leave? If they have a child with autoimmune issues who might be subject to one of the paid sick leave buckets, we may have a requirement to provide the paid sick leave. If the employee continues to not want to come to work prophylactically, I don't know that unemployment would be available simply because they have a child that's sick, but it's more likely that the unemployment could apply for that person who is caring for someone who maybe, if they do have autoimmune issues, are going to be subject to a healthcare order to be isolated. I would also say EFMLA might be applicable if that child's school or daycare has closed, as well as the paid sick leave provision. The next question is, we have under 5 employees, all of which can telework, so they do not qualify. Correct. But what happens if they could be put into one of the buckets? Does that trump the telework exception, so now they qualify? No. If an employee is capable of teleworking, even if they have a child whose school has been closed, you do not have to provide paid sick leave or EFMLA. If the employee is capable of teleworking, they do not qualify for the provisions of the Act. As I talked about before, query whether we'll start to get employees who say, well, I just can't telework because of the distractions going on at home. But presuming that they can telework, they would just be paid their normal salary and they would not be provided the benefits under the Act. What documentation should we have for both FMLA and sick leave? Again, I think it's very important that we have documentation that shows by date what bucket of sick leave an employee utilized, so that if audited by the government, we have the ability to show why we paid somebody a certain amount. For EFMLA, is the 30-day requirement 30 days prior to April 2nd? I believe for EFMLA, it is simply 30 days prior to the date that they would seek to take EFMLA. And frankly, excuse me, frankly, I think EFMLA is going to be applicable just about everybody except for your brand new hires. And I think that is it in terms of questions. I think, oh shoot, no, I take that back. I just didn't scroll down. We'll take one more, and then I will make sure to follow up with any questions that I wasn't able to respond to on the phone. If we choose to offer the 80 hours of paid sick leave, assuming not required as employees are out due to stay-at-home order, will we still be able to recoup the cost via the payroll tax reimbursement? And I think this question is, excuse me, for those employees who are out now under Ohio or Indiana or Michigan or another state stay-at-home order, can we give them the paid sick leave now and then be reimbursed after the act becomes effective? And again, my answer would be no, not without risking that the government will not reimburse you. As I said before, we should have documentation that supports on what day and for what reason somebody took leave and was paid, either paid sick leave or EFMLA. And my concern is that the act is not retroactive, and therefore, if our documentation shows that somebody took leave before April 2nd, that leave would not be subject to reimbursement by the government. You could certainly do it, just know that you will have the obligation to provide the 80 hours of paid sick leave effective April 2nd as well. So I think we'll end there. I appreciate everybody's time and look forward to working with you on these very key issues in the future. So thank you all and have a fabulous day.